The Graham-Leach-Bliley Act was enacted in 1999, and under this act, all financial institutions are required to disclose their policies and practices for protecting the privacy of non public personal information, and also to allow customers to opt out of information sharing arrangements with non affiliated third parties. And that is the Graham Leach Bliley Act. HIPAA, the Health Insurance Portability and Accountability Act, which was enacted in 1996, but it took effect in 2003, includes privacy protection for medical records. This law gives patients access to their personal medical records that healthcare providers, hospitals, health insurers maintain, and the right to authorize how protected information about themselves can be used or disclosed. So, under this law, doctors, hospitals, and other healthcare providers must limit the disclosure of personal information about patients to the minimum amount necessary to achieve a given purpose. So, they still have a little bit of leeway on this, but pretty much protected. The FTC has got certain principles, and they're called freedom in the internet age. And this privacy and freedom in the internet age pretty much looks at the FTC FIP. So the FIP stands for Fair Information Practice Principles. So you have a notice or the awareness for the core principle. Then you have a choice or consent as the core principle. You have the access and participation, security, and enforcement. These are the five principles of the fair information practice. So, under the notice or awareness, websites must disclose their information practices before collecting data. It includes identification of the collector, uses of data, other recipients of data, nature of collection, etc., etc. The choice or the consent must be in place, allowing consumers to choose how their information will be used for secondary purposes other than supporting the particular transaction. The access and participation tells that the consumers should be able to review and contest the accuracy and completeness of data collected about them in a timely, inexpensive process. In security, data collectors must take responsibilities or responsible steps basically to ensure that consumer information is accurate and secure. The enforcement is a mechanism, and that must be in place to enforce these FIP principles or the freedom, the fair information practice principles. The internet challenges to privacy basically is based on three things, which are cookies, web beacons, and spyware. Everybody talks about cookies. So, cookies basically is a small text file. This text file is deposited on a computer hard drive when a user visits websites. Cookies identify the visitor's web browser software and track visits to the website. That's it. So, how it works basically is during the HTTP request, the web server reads the user's web browser and determines the operating system, the browser's name, the version number, the internet address, and any other information like the email address, so on and so forth. The server then transmits a tiny text file, which is a cookie, with identification information. The browser receives that and stores that in the user's computer. This is done without your knowledge or anybody's knowledge. When the user returns to the website, the server requests the contents of any cookie it deposited previously, which is in the user's computer. The web server reads the cookie, identifies the visitor, and calls upon data on the user. At that time, when it identifies the user, it can add advertisements, targeted marketing advertisements, and anything else. Their names, welcome back, so on and so forth. So, cookies identify browser and track visits to the site. The web beacons or web bugs. These are tiny graphics embedded in emails and web pages. These web bugs report any data back to whomever owns the tracking file, invisibly embedded in email messages and web pages. Web beacons are placed on popular websites by third-party firms. Actually, there is a Wall Street Journal article which says that they discovered 3,180 tracking files installed in visitor computers. Only one website, Wikipedia, has no tracking files. The biggest trackers are Google, Microsoft, and Comcast. All these three companies sell ads to advertising firms and marketers. So Google, Microsoft are the two big ones, and Comcast is another company. Another study found tracking on the 50 most popular sites has risen fivefold due to the growth of online ad auctions, where advertisers buy the data about users' web browsing behavior. There are also other spyware. For instance, malware bytes is a spyware. They are surreptitiously installed on users' computers. And malware bytes actually uses the surreptitiously installed computer, the installed, all these spyware, and brings it to light to you. They actually help you. But companies can go and install them, and if you use malware bytes, it actually helps you to discover these spyware and delete them. And Google services and behavioral targeting we talked about already. The technical solutions for all these things are email encryptions, anonymity tools, and anti-spyware tools. So anti-spyware tools, I would highly recommend that you guys take a look at malware bytes. And email encryption is done by many companies. Any email like Google has got encryption files that can be used. So overall, in summary, technical solutions have failed to protect users from being tracked and from one side to another. The same thing goes for intellectual property. Companies have inventions, and these inventions can be looked at as intellectual property. These are tangible, intangible products of the mind created by individuals or corporations. These intellectual property are protected in four ways. We all know this. We know what is a copyright, what are patents, what are trademarks, and what is a trade secret. These are the four ways of protecting intellectual property. The challenge is that the digital media is different from physical media like paper and books and things like that. And digital media gives you ease of replication, it gives you a ease of transmission over the internet, it gives you ease of alteration, it is compact, and it is very difficult to establish uniqueness. There is an act that actually was passed in US called Digital Millennium Copyright Act. The DMCA, or the Digital Millennium Copyright Act, was enacted in 1998. It provides some copyright protection. Actually, what they did was to incorporate a World Intellectual Property Organization treaty. Internet service providers are required to take down the sites of copyright infringers they are hosting when the ISPs are notified of the problem. Microsoft, another major software like Adobe, are represented by the Software and Information Industry Association called SIIA, which is Software and Information Industry Association. If computer fails, who is responsible? These are questions that you need to think about. If seen as part of a machine that injures or harms, software producer or operator may be liable. If seen as similar to a book, difficult to hold, author or publisher is responsible. If seen as a service, then would it be similar to telephone systems not being liable for transmitted messages? We don't know. So these are the things that we need to think about when we talk about computer related liability problems. In the systems quality, data quality and systems errors are important. What is an acceptable, technologically feasible level of system quality? Basically, it is flawless software, but it is economically unfeasible. There are three principal sources of poor system performance. One is software bugs or errors, hardware failures, or poor input data quality. This is actually the poor input data quality is the most common source of business system failure. They also say this as garbage in and garbage out. So that concludes chapter 4. Please do the eyes following this, and I will give you some more information on the final exam and a project later on in the next class. Bye. Stay safe.